Test 1, 2, 3. Hi, very good afternoon and greeting from EPLI Asia's neighborhood. My name is Sudev and I'm the CEO of EPLI Asia's neighborhood. Welcome to our fourth webinar in our Arts and Science series. And this time around, we'll be discussing on termination. As for those of you who are viewing our webinar on YouTube, please click the subscribe button and do share the videos on our EPLI Asia YouTube channel to your colleagues and friends. Also, do look up EPLI Asia on LinkedIn and Facebook and join us there for updates on EPLI and future webinars. Employment Practices Liability Insurance, or EPLI, is a HR risk management solution that was designed by EPLI Asia's neighborhood. It's a standalone employment insurance for Malaysian employers that protects you against wrongful dismissals, claims that arises from employment disputes. I'm glad to announce that EPLI insurance, or Employment Practices Liability Insurance by EPLI Asia, is now available for all employers in Malaysia. This is the one and only of its kind here in Malaysia, whereby EPLI Asia's neighborhood offers a 3-in-1 solution, whereby we educate, advise, and protect businesses in employment-related disputes. The EPLI by EPLI Asia is underwritten by 2 insurance companies here in Malaysia, and they are MSIG Insurance and Tokyo Marine. For your information, there are many EPLI products out there in the market, but for a robust, reliable, and sustainable HR risk management plan and solution for your company, which comes with advice from competent HR and IR advisors, make sure you buy the 3-in-1 EPLI policy from EPLI Asia's neighborhood. For details on how your company can purchase the EPLI policy from EPLI Asia's neighborhood, do visit our website at www.epliasia.com or email us at our contact details at epli@epliasia.com, and we will be contact you as soon as possible. Also, do join us in our product briefing, which we conduct via Zoom every Thursdays live at 2 p.m. Now, for the Art and Science series, this is one of our ways of how we actually educate every Malaysian on the laws that govern our employment practices here in Malaysia and how it's actually applied in real life scenario with real facts. And for today, our experts Supra and Daman will be discussing on the employment termination in Malaysia. Well, I've been looking forward for this for some time now. So let's kick off this presentation and discussion by me introducing our moderator, Mr. Supra, and Mr. Daman, who's going to be the panelist for today. Over to you, Supra. Supra is on mute.
Sorry. Thank you, Sukhdev, for sharing the information. A very good afternoon, everyone. Welcome again to our April Art and Science series. It's good to know that we've got more than 600 participants sign up for today's session. We sincerely hope everyone greatly benefits from the session. Our topic today is the art and science of termination in Malaysia. So in our discussion, we'll focus on understanding the employer's right in terminating, understanding the element of procedural fairness in managing termination, the common errors in termination of employment, and also understanding the procedures in handling involuntary termination and how to mitigate your risk as much as possible. Although many may argue that the Malaysian employment law is pro-employee, but the fact is the law is not unfairly skewed in favor of employee. One may say that the percentage of the court ruling in favor of employee was higher in the past, especially if we look at the many dismissal cases in the 90s. However, if we look at the present dismissal cases within the past 10 years or so, the ratio for the court to decide in favor of between the employers and the employees are distributed fairly, depending on the facts and merits of each case. Despite the fact, right, we had the latest IR Act Amendment 2020, which took effect January 1st, 2021, which could possibly impact the rise in the number of cases being referred to industrial court, especially with the removal of the ministerial review, and it is being now handed down to the Director General of Industrial Relations, and to automatically refer all unresolved claims to the industrial court. Therefore, it is important that all employers has to tighten their processes and procedures even more so to prevent unnecessary risk due to negligence. Our panel today, we have Mr. Dharman Sivalingam, and our sincere apologies that our other panelist, Mr. Wicked Gunn, the CEO of MECA, is unable to be present today due to health reasons. So we have got Mr. Dharman Sivalingam, the EPLI's panel solicitor and managing partner of Dharman Sivalingam and Partners. I don't need to tell you that he's got 25 years of experience again, because I think I keep repeating that all the time. Okay, welcome and thank you, Mr. Dharman.
Hey, thanks, Supa. Hello, everyone.
Okay, thank you, Dharman, for being here. So before we start the session, I did mention about, the latest Industrial Relations Amendment, okay, 2020, which took effect January 1st of 2021. Could you share with us briefly about the key impact of that act from a termination perspective, which is the topic of our discussion today?
Sure. Good question, Supra. I think because of its relative newness, there's still a little bit of, shall I say, the full effect of the amendment may not be appreciated by everyone. But in respect of our topic today, I think the amendments bring about changes, two aspects. The first aspect, I'll say three aspects actually. The first aspect, as you are aware, in the past, prior to the amendment, if there's a dismissal, an employee who wants to challenge the dismissal files a complaint with the IR department. The IR department then calls parties for a conciliation meeting. If conciliation is unsuccessful, and here's where the change, formerly it used to be the case that the unsuccessful conciliation matter gets referred to the Human Resource Minister. And the Human Resource Minister exercises his discretion. And the discretion allows him to decide, shall I refer this matter to the industrial court, or should I not refer the matter to the industrial court? So there is the possibility prior to the amendment for cases which could not be settled amicably at the IR department, for it to end at the minister's stage, i.e. the minister makes a decision that I don't think this matter should be referred to court, as it seems to be a straightforward case, and the matter basically ends there. Unfortunately, or fortunately, this is the amendment. The amendment now does away with the HR minister's role, which now means with the new law effective 1st January 2021, any unsuccessful conciliation will be referred to court by the Director General of Industrial Relations. So that's the first change. There is no more discretion of whether to refer or not to refer the matter to court. Because if you look at the amendment, the wordings used is the DGIR shall refer. Now, shall typically means no discretion, you must refer. So if no settlement, regardless of the merits of the case, the matter gets referred to the industrial court. The second aspect of the amendments that I think are relevant here for our topic today is that Because the DGIR doesn't have the discretion, there is no possibility to challenge the DGIR's decision to refer. Now, formally, the minister has the discretion to refer or not, and potentially there could be a party who challenges the decision of the minister. But now, because the wordings of the amendment says shall, every matter that cannot be settled amicably automatically gets referred to court, and you can't challenge the decision of the DGR. That's the position as it stands now. Whether there's going to be changes to that, or whether there will be challenges, yet to be seen. By my opinion, because of the word shall, he doesn't have a discretion. And I think the third slight relevance of the amendment to our topic is there is, from a decision of the industrial court, you don't go by way of judicial review anymore. So this is after a decision of the industrial court. If you want to challenge that decision, the amendment says you appeal to the High Court, not judicial review. But I think the most important amendment is the first one. There is no more discretion if a matter is not settled. So if a matter is not settled at the conciliation stage, it gets referred to the industrial court. I think that's what I'd like to say about the amendments for our topic today.
Thanks, Raman. So to sum it up, even if I've got a very strong case and I've put all your procedures and process and all that, right? When I go to the IR office, so if it's now going to the Director General of Industrial Relations, I do not want to settle the matter because I have adhered and complied to all the processes. So the DG doesn't review and say, okay, I think this case shouldn't be referred because the company has done everything right? Or maybe 99% right. He is still going to refer the matter to court. Am I correct to say that?
Absolutely.
Thanks, Daman. Just to clarify that, okay, because there's some confusion in that area of it. Okay, let's kick off our discussion. Okay, so as usual, my favorite is to always ask you everything from a general context, then I'll relate it back to employment context. So what's the general definition of termination, right? And also then you give me a perspective from the employment aspect of it.
Okay. And again, that's a very interesting question because the words termination, dismissal, these are words that we also use in normal language. But when it comes into the realm of employment laws, it has got certain specific meanings that are ascribed to it. So termination, in simplistic terms, basically it is the ending or cessation of a relationship. So from, I guess, when we talk about termination in this context, we are referring to the relationship between the employer and employee. If there's a termination, what it means is that relationship comes to an end. That's how I would look at termination.
Thank you. That brings me to my second question, which I actually love this, right? What's the difference between, this word being used, right? Between dismissal and termination. What's a clear difference between the word dismissal and termination? From an employment context, I'm talking about, yeah.
Sure. And I think if I were to give it some context, the context is really coming from Section 20. Now, Section 20 basically states that where a workman believes that he has been dismissed without just cause or excuse. So Section 20 uses the words dismissal. And so now, does that mean that word dismissal has a specific definition in employment law? Now, my view is that, and I think you'll have various authors who tell you who might paraphrase or who might give certain definitions or confined definitions. I think one of the definitions is that dismissal is where it is unilateral or involuntary, where the employer has decided to dismiss. But from a context of a Section 20 Industrial Relations Act perspective, I will say that when the word dismissal is used there, it refers to any reason or any cause which brings the employer-employee relationship to an end. And there are various reasons, as we will delve deeper later today. But to me, the word dismissal is used in Section 20. It will cover the entire scheme of any event which brings to an end that relationship between an employer and an employee.
Cool. My next question to you, Section 13.3 of the IR Act actually states that dismissal and termination of employees are regarded as management prerogative, right? So if it is referred as a management prerogative, then why is it so difficult to dismiss or terminate employees in Malaysia?
Yeah, okay. Again, another excellent question. I think I haven't been asked this many questions since my last interview, but I shall answer the question anyway. Now,
consider you're in an interview that, you know what, I'm going to hire you for a job.
Okay, I better put my best foot forward here. My starting point on that question, if you read Section 13.3, Section 13 of the Industrial Relations Act comes under the area of collective agreement or collective bargaining. And Section 13 sub 3 states that whatever, I believe it says notwithstanding subsection 1 or something along those lines, and I don't want to use too many legal languages, it states that you cannot include in a collective agreement any term which is related to one of the issues below Section 13 sub 3, the subparagraphs of Section 13 sub 3, and one of it is what you just pointed, which is the hiring, the firing, and so on. Now, although Section 13.3 talks about collective agreement, now, and maybe just to get everyone on the same page, collective agreement is a document that is signed off between a union and a company, which covers the terms and conditions of employment. And so Section 13 sub 3 says you cannot include anything in relation to termination or employment in a collective agreement because that is considered management prerogative. So that is for management to decide on its own without any confines or without any controls, especially by the employee or by the union. So even though it comes under Section 13 sub 3, which talks about collective agreement, you are right, it is a management prerogative. But I guess to answer your question, all these provisions are subject to overarching principle of Section 20, which is you may have the prerogative, but your prerogative has to be exercised properly. Meaning to say, if you were to fire someone without just cause or excuse, even though you are saying this is my prerogative, it is still subject to the overriding principle in Section 20, which is the dismissal should be with just cause or excuse, because if it was challenged, you can't just come to court and say, but look at Section 13.3, it gives me prerogative. The law will turn around and say prerogative within the confines of what's fair.
Thank you, sir.
Yeah.
So, which means that I've got the right to hire, but I got no right, absolute right to fire.
I would certainly agree with you on that.
Got to move my business to Singapore then. So, in this context of it, when can we actually dismiss or terminate an employee?
Okay, so, and I guess that there's a theoretical answer and a practical answer. So the theoretical answer is actually, if you look at it, dismissing an employee or terminating the services of an employee is, you can do it very easily in the sense that all I need to do is come up with a letter, give it to the employee saying, hey, here, today is your last day, out you go. I can then even inform my security guard. Next time you see the guy, if he tries to come in, you stop him. And that's it. That brings an end to that relationship. So from a theory perspective, it's very simple. But if we bring the law into it, and if that person then challenges that dismissal, that's when employers get into a big spot of bother, because Section 20 then comes in, and you as an employer have to justify that dismissal. So to answer your question of when can you dismiss, any dismissal can be challenged, any termination can be challenged. If there is a challenge, if for you to be able to succeed in your court, you will have to be able to show that your dismissal was with proper reason. So if you're relying on a misconduct for the dismissal, there is a set of procedures and laws that we have to follow, which we will have to demonstrate in court before court decides whether it's fair or not. If we're going to go down the route of performance, there's a different set of procedures and principles that have to be followed, which the court will judge. Likewise, if it's retrenchment, yet another different set. So I guess to answer your question, you can dismiss for any of the reasons I've mentioned: misconduct, performance, retrenchment, so on and so forth. But if there is a challenge, you must be in a position as an employer to demonstrate that that dismissal was with just cause or excuse. I hope that was that made some sense.
Yeah, cool, thanks. It's just that I think someone leaked my questions to you. I think could be Sukhdev. You know, you have answered the next question that I'm about to ask you. So
Right.
there is a leak in our system here.
Looks like a misconduct.
Okay, next one. I'm trying to understand this, right, from the context of, you know, at-will termination versus the law of natural justice. Could you enlighten us the difference between the two? Okay. Technically, I understand in Malaysia, we can't practice at-will termination, but maybe you could share us your experience and from your legal perspective, why did that actually come about? How did it come about?
Okay. Okay, so maybe the convenient starting point there is to give a quick definition of at-will termination. So at-will termination, as the name suggests, is at my will, at my discretion, at my decision, regardless of anything else, I terminate. And typically when we talk about at-will termination, we are referring to the will of the employer. So meaning to say, purely at the employer's will, purely at the employer's decision, regardless of any principle, regardless of anything, I want to terminate. And the funny part, I guess, is if you look at any typical employment contract, there will be a clause which states either party may terminate by giving notice. That actually seems to indicate you allow at-will termination. But you are right just now when you said it's not allowed in Malaysia. Why is it not allowed in Malaysia? Well, is it allowed, not allowed? Okay, let me answer this way. If an employer terminates at will without any reason, and the employee doesn't file a complaint within 60 days, guess what? At-will termination allowed. He gets away with it. But if the employer terminates at will without any reason, and it's challenged by the employee by filing a complaint under Section 20, that is why at will is not allowed, because Section 20 will supersede the contract, will supersede the concept of at-will termination. So meaning to say, if there is a challenge to that dismissal, the employer must be able to prove that the dismissal was with just cause or excuse, failing which the employer ends up in trouble. Now, going to your next question as to why. I believe this is why. You see, the reason why, as I mentioned just now, the reason why at-will termination is not allowed is because of Section 20. Now, so how did Section 20 come to pass? How did it become law? It was passed by Parliament, just like any other statute or any other law in Malaysia. So meaning to say, it was a governmental policy. Malaysian government decided that in Malaysia, we want to provide security of tenure for all our employees, as opposed to, for example, America, or as you mentioned earlier, Singapore. So in those countries, at-will termination is allowed. You do have some recourse to the law, but certainly not the full extent of the protection that Section 20 provides. So it is, the why is because it's a national policy. which resulted in Section 20 being passed and that becoming the law. If you want to debate which is better, there's always going to be pros and cons for both sides. I think we don't live in an ideal world where all our employers are fair. So because you're going to have a mixed bag of some employers being fair and probably more not being fair, I can see the merits in saying no at will termination, because the way you exercise your will, you naughty boy, is not proper. And so that's why I provide the protection of the law. Whereas if Singapore, for example, I can see why they allow it. They're such a small country. They don't have a lot of natural resources, very little land. So for their economy to thrive, they need to attract investors. And guess what? Investors prefer an environment where there is at-will termination. So the policy of that nation to attract foreign investments is to make laws which are pro-employer, and so they went down that path. Malaysia, I guess, we are blessed with land, we are blessed with good weather. So, we have some, I would say, definitely relative to Singapore, more natural resources. And so we followed the path of security of tenure, so at-will termination can be challenged.
Thank you, sir. Okay, we discussed about the law of natural justice, and the principle of natural justice indicates every termination must be with just cause and excuse. Okay, maybe to enlighten us all, you could share with us, what does just cause and excuse really mean?
Okay.
Yeah.
So again, that's a little bit of a moving target, and I'll tell you why. First, let me come back to your the term natural justice. I would like to use the definition of natural justice that I would use as a general definition, because natural justice plays more of a significant role in misconduct. But generally, natural justice talks about the minimum standards of a fair decision-making process. Right? So I think any fair decision-making process, what are the minimum standards? So, and we could use this for anything we do. Let's say, even as a parent, if you're going to discipline your child, let's say you see you hear your child shouting and you call your child and give him a slap. Now, is there a minimum standard of fair making, minimum standard of fair decision making? In my opinion, no lah. This child may have a reason why he shouted. Maybe he fell down, hurt himself. So if we don't exercise the minimum standard, which is to inquire, why did you shout before I go with the slap? Right? So if I go with the slap, I've already prejudged. You've done something wrong without knowing anything. So there's no fairness in that decision-making process. So that's, I would say, in a nutshell, the essence of natural justice. The minimum standards required before you undertake a fair decision-making process. Now, if you drill down into just cause or excuse, again, it's linked, as you mentioned, to that same concept of fairness in the decision-making process. But why I say it's a moving target is, what is just cause or excuse for misconduct is different compared to just cause or excuse for poor performance, compared to just cause or excuse for retrenchment. Because the law recognizes the difference in each of these types of dismissals, there is a different requirement for just cause or excuse. But ultimately, it comes down to being fair. Just cause or excuse, I would say the best definition for it in simple English is fairness. So the only moving goalpost there is, if it's misconduct, fairness has a slightly different meaning because the process is different. If it's poor performance, fairness is defined differently. If it's retrenchment, fairness is defined differently yet again. But ultimately, just cause or excuse, in a word, I would say fairness.
Okay, then how do we actually determine something is fair or unfair? Because what is fair to you could be unfair to me.
Absolutely. And I think this is where, when you talk about employment law, it's a live area. It's an area where you're talking about human element, human behavior, human values, humans standards. As you say, what could be fair for one person may not be fair to another, and vice versa. It's you like durians, I hate durians, right? So does that mean durian is bad? No, but that's the conundrum that we find ourselves in. We are, from a legal perspective, the judgment is on the durian. Whether it's good or bad actually depends on the person who's eating it, right? And it's very gray, and I guess that's the nature of the law generally, but more so, I suppose, when it comes to employment law, because that human element becomes that much more relevant. The circumstances, to give you an example, if you're in a company which has got lots of policies and procedures written out, it's possibly easier to let go of someone because those policies have been written out. So if I have a policy which says you can't, let's say, you can't do a certain type of product, all right, or you can't do a certain act, and that's written down in a policy. So in that environment, if an employee goes against that policy, it's easier for you to justify dismissal. But in the same act, in another environment where those rules have not been made clear, the court might even say, but how you expect him to know that, and so how are you going to dismiss him for that? So I guess I will have to differ. I will have to agree with you that this is not it's something that you cannot say with mathematical precision. A
Okay,
lot depends on facts and circumstances.
then how do you then establish what is procedural fairness in the context of the employment termination? Because say there must be steps taken in disciplinary or dismissal process. So, but it must adhere to procedural fairness, right?
Yeah. So procedural fairness is something that has largely been developed by case law over the years. So thankfully, um, through the efforts of some brilliant judges and lawyers who have put forward arguments, and some brilliant judges, they've distilled certain procedures which have now become accepted as what should be the right procedure to follow before you dismiss someone. So again, if it's misconduct, the procedure that you have to follow, the typical procedure, which I will share a little bit later, your show cause and DI and so on, that has been built over the years by case law. And case law now gives us a guideline as to what would be acceptable procedural fairness to act on a misconduct. And likewise, when it comes to performance, the body of law has developed and it's been sharpened and added on and built on. And now there is some level of clarity as to what is the procedure that you want to follow for performance related dismissal. And likewise, what's the procedure for a retrenchment scenario. So procedural fairness is something that has been developed by the body of law over the many years that cases on these kind of areas have gone to court, and then there has been development on these areas.
Thank you, Daman. Now I drill down to more about termination matters. Okay, for employees under the Employment Act, a domestic query is essential, right? And it's always better to conform to it on the side of fairness and natural justice. But my question is, why is DI essential in the context for those governed under the Labor Act, but those not governed under the Labor Act, DI is still debated in court sometimes. Sometimes the court says, yeah, I think in the absence of DI, but they established the case, I think it's fine. And they use other cases as a reference to say it's okay not to do the DI. But in some cases, they say, no, for the failure of the company to not do the DI, right, it then jeopardizes the case of the company. So the inconsistency there, actually causes employers, confusion, right? Because Not every HR manager or employer in the country who is trained like you in the Industrial Relations Act and all that stuff, right? We're not lawyers, right? So shouldn't we have something clearer? And this for me is a bit confusing.
Okay. Again, let me just explain a little bit more to set a bit of the context. You're right. In the Employment Act, Section 14 uses specifically the words, before you punish for misconduct, there must be due inquiry. And due inquiry has largely been defined to mean a domestic inquiry. So maybe to start this discussion, the Employment Act, so that we're all on the same page, the Employment Act generally applies to employees whose wages do not exceed 2,000 ringgit. Or the next category is even though your wages are more than 2,000, but you are predominantly engaged in manual labor. And then you've got two other categories: supervisors of manual laborers, those who maintain and operate mechanically propelled vehicles, and so on. Now, starting point, why do we even have the Employment Act only applying to those categories? Why can't we have the Employment Act applying to every employee? Yeah. And I think the reason behind that is generally in any country that practices democracy, and we are supposed to be practicing that, the freedom to contract is allowed. So, meaning to say, two parties can enter into any contract on any term so long as the object of that contract is not illegal, right? So to give you a silly example, I could decide to sell you my house for 1 ringgit. Now, it seems to be a very stupid decision on my part, but the freedom of contract states, hey, as long as both parties willingly want to enter into this contract, the law, the government should not interfere, so long as there's no illegality. But when it came to employment, the law had a slight deviation. And in my view, I think it's with good reason. The reason is simply this. If you look at the categories of the employees covered by the Act, 2,000 and below, manual laborers, predominantly engaged in manual labor, we are referring to that demographics of society who are not highly educated, who are not very empowered with their knowledge of their rights. And therefore, to give them a level of protection, the law felt, I know this goes against the freedom of contract, but the need to protect these people who don't have that level of education and so on supersedes the concept of freedom of contract. And so for these people, the Employment Act comes in and says you must have certain minimum standards, including the need for a due inquiry before you can dismiss for a misconduct. But when it comes to those outside the Employment Act, the law starts, and that's the line was drawn at right or wrong. It was drawn at 2,000 and below, manual labor, and so on. But once you're outside, the law says, hey, you know what? Let's recognize freedom of contract. Let's leave it to the parties to willingly enter into any contract they want. So as ridiculous as it sounds, if you and I entered into a contract for employment and you tell me, okay, Daman, I'll give you 5,000 ringgit or 6,000 ringgit, but your hours of work shall be 7 a.m. to 11 p.m., 7 days a week. And if I say yes to that, that's perfectly allowed. But that is not allowed for someone who comes within the scope of the Act. Again, because the law makes an assumption, that person who comes within the Employment Act probably is more easy to be cheated, manipulated because of their lack of education, their lack of exposure, and so on. So I think that's where you have this sort of slight diversion. And there's a little bit, for want of a better word, a little bit more support for those employees who come within the scope because of the assumption that they can't protect themselves as well as someone who's highly educated, highly exposed, and highly experienced.
Okay, so technically sum up is those governed under the EA, DI is an absolute must, okay, whether it's a misconduct or a non-performance issue, okay?
Okay, I would, if I just add something there, I wouldn't say it's an absolute must. Definitely best practice. When it comes to DI for performance, I would also say that is very good practice. I wouldn't say it's an absolute must. Yeah.
Okay.
But let me stop there. I think that's the only additional part I wanted to say.
So then for those above the EA, right, you go on a case-to-case basis, but having a DI would be a good thing because you still, you're giving a bit of impartiality to the company to have a panel to actually decide and not just the CEO or whoever and the management to make the absolute decision, without having independent opinion before you terminate someone. Am I correct to say
Absolutely,
that?
you're absolutely
Yeah.
correct. And don't forget one final part. Whether you come within the scope of the EA or outside the scope of the EA, if you're going to challenge a dismissal, everybody comes under Section 20. And Section 20, as we earlier demonstrated, what does just cause or excuse mean? It simply means fairness. And I think everyone would agree, if you had a DI as opposed to not having a DI, your chances of showing fairness is greater if you had a DI compared to not.
No, we're running out of time because we're supposed to get into your presentation, but I've just got two questions before that. One is, I'd like to understand the function of the Industrial Relations Office, okay, when you got the Industrial Relations Court, because most times we are just going to the Industrial Relations Department just to present the employee case, present the employer case, and the officer asks, do you want to settle the matter? And then if you don't want to settle the matter, and now with the new regulation, your amendment saying all goes to court. So my question is, why are we wasting time doing that?
It's a very controversial question. There are many IR officers around. So
No, I know, but I have to ask the question because you know what? Unless there's a value added in that process, because I represent a lot of Malaysian SMEs, and I think I'm speaking for the employees who are feeling there's time wasted. Right?
Yep. And I think you are certainly not alone in that. I think I would say a large percentage of employers who've had the unfortunate experience of going to the IR office would agree with you. And okay, so the word that is used in the law is conciliation. And conciliation is actually more than just you want to settle how much you want, right? So conciliation is an art. It's an art to try and get two parties where there's a gap, to try and close that gap by getting both parties to understand there is a middle ground, which is a win. Yeah. Now, my belief is that the reason for conciliation, number one, is avoiding litigation wherever possible. Yeah. And I think the why behind that is it becomes our system is not made to be able to go through too many volumes and volumes of dismissals. So that's one of the main reasons. And a very well undertaken conciliation can be a super mitigating tool to reduce number of cases that end up in court. But when I say a well undertaken conciliation requires someone who has the ability to explain to two parties who, don't forget, they are at loggerheads, and especially when you talk about IR department conciliation, it happens pretty soon after the dismissal. So emotions of both the parties are running very high. The incident just happened, and now they're in a room together. Both of them probably smoke coming out of their ears. So you need a super strong conciliation officer to say, listen, these are the pros and cons. This is the process. This is what could happen. There is no guarantee for anyone. I am not here to judge who's right, who's wrong. We are trying to see if there is a middle ground where both of us can sign off on an agreement and walk away and drop this baggage. All right. And then a good conciliation officer should go into the details of gaps in each party's case and explain to them that hey, listen, I understand from principle standpoint, you think what you did is perfectly right. I'm not here to judge otherwise. I'm just here to point out these are some concerns that I have seen. These are some concerns that if it goes to court 1.5, 2 years later, and you don't have your witness, you could compromise your case. Likewise to the employee, to say that, hey, the company has followed a procedure. It looks like you also did not want to improve your performance. They put you through a PIP. They asked you to give your views on it, but you kept silent. But then now you want to file a complaint. So a well undertaken conciliation, I can see tremendous value. But unfortunately, I will agree with you that I think a well undertaken conciliation is very much in the minority. The majority of conciliation that happens is how much you want. Are you willing to pay this? Or you don't want to pay this? Huh? Okay. And then if you approach it from that angle, I would agree that it probably serves no purpose.
If you explain conciliation meeting the way you had explained, I would completely agree with you. Okay. So, Daman, we're running out of a bit of time. Just give me, before you go into, okay, there are two types of termination. One is the voluntary and involuntary termination. Just give me a brief definition or rundown of these two components, because I believe you're going to focus a lot on the procedures of the involuntary termination, right, in today's presentation. So maybe just before you start your presentation, just to give everybody the perspective of it.
Okay, so it's quite straightforward. A voluntary termination basically means the employee has agreed or has accepted that his or her contract of employment is coming to an end. Typically, that acceptance or agreement is obtained by the exchange or for consideration of money. So you're talking about a voluntary separation scheme or a mutual separation scheme where employee says, okay, for that amount of money, I'm willing to voluntarily allow my contract of employment to be terminated. As opposed to involuntary, where it is normally one party, and generally it is the employer who decides to terminate the contract of employment despite the non-acceptance or rejection of the same by the employee.
Thank you. And without further ado, if you want to learn how to dismiss an employee legally and lawfully by Mr. Daman, let's welcome Mr. Daman with his presentation. Mr. Daman?
Thank you for that, Supra. Ashadi, could I have my slides, please? So as Supra mentioned, I will be focusing on involuntary termination on today's Art and Science of Termination series. So this is where the employer has decided to terminate. And let me start. Next slide, please, Ashadi. Let me talk to you about the scope of this paper. My paper is going to be confined or focused on 3 types of dismissals: misconduct, poor performance, and retrenchment. I will go into the legal principles that you need to comply with in order to support a dismissal for these 3 reasons. I will also talk about the procedural fairness or the right procedure to adopt in respect of each of these types of dismissal. I will spend a bit of time on what does a successful dismissal require, what are the elements that you would need to be able to successfully dismiss an employee. And the last part would be the common pitfalls or the common mistakes that employers tend to make in managing these types of dismissal. So this is going to be my scope of my paper. And let me move to the next slide, please, Ashadi. So the recipe for success, what are we talking about here? And I've started with the first question of how do we define success? My view on this area is that you've got 2 types of definition of success. And the first one is the sweetest, the best one, where the dismissed employee does not, or all dismissed employees do not file a complaint. So there's a dismissal, contract of employment comes to an end, nobody files a complaint. That is really sweet. But the second type of success is it may not be possible for you to get to a situation where the employee says, I'll accept that and move along. You might often find yourself in a situation where the employee says, I think that's unfair, I'm going to challenge this. So the second definition of success is, how do you defend that complaint? How do you win in court? Right? And if you look at I break down the two types of success. If you want to avoid complaints altogether, that is only possible if you can come to a situation where the employee has accepted the dismissal was fair and the employee wants to move on with his life, his or her life. And what are the main tools that help you get to this end is basically, I put 3 things down there. Number 1 is you can't run away from the procedural fairness. You need, if you want the employee to accept that the dismissal was fair, the employee must feel that he or she went through a process that was fair, that gave him or her a chance, and ultimately they accept the decision. Number 2, treating people with respect and dignity. Even though someone is going to be released, the manner in which we deal with them, the manner in which we tell them the news, the manner in which we conduct the procedure, the process is very important. And lastly, communications, right? So when you communicate with an employee, if you communicate in the right way, it is my experience that you have a higher chance of employees accepting that this dismissal is, I'll accept. I may not be happy with it, but I think the company was fair with me, and they move on. But the second definition of success, which is defending a complaint of unfair dismissal, what does this mean? What does this require? The main one is the evidence to support that the dismissal was done properly. And this quite simply means you have to comply with the legal requirements, with the procedural requirements. All of that becomes important. And of course, if you're in court, not only must have you complied with the law and complied with the procedure, you must be able to demonstrate that you had done so to a judge. You must be able to do that through your witnesses and through evidence that you have to show to the judge that the dismissal was fair. Right? So to me, that's how you successfully manage dismissals. Next slide, please, Ashadi. Let's talk about the first area, misconduct. All right, so very quickly, what does misconduct mean? Misconduct means an employee is alleged or suspected of having done something which is in breach of his contract of employment. It's a wrongdoing. And if the employee is suspected or alleged to have committed a wrongdoing, what are the legal requirements that you need to comply with? Number 1, there must be some proof around the fact that the employee did in fact commit the misconduct. It cannot be speculative. It cannot be purely based on the subjective opinion of one person saying, you know what, I think he did it. So there needs, of course, you will never come to a situation where 100% you're certain that the employee did it. But it cannot also be overly speculative or based on one individual's perception per se. So you must have evidence of the employee committing the misconduct. And number 2, the punishment of dismissal, which is the most serious punishment that an employer can impose on an employee, that punishment must be fair relative to the misconduct that has been committed. So, for example, again, not a great example, but to illustrate and emphasize the point, if an employee comes in 2 minutes late, do we want to dismiss that employee? Sure, we might be able to show because of the punch card that he was 2 minutes late, but dismissal in that instance would certainly be way too harsh relative to the misconduct that he or she has committed, which is being late by 2 minutes. And of course, if you talk about misconduct, earlier I mentioned in my discussion with Supra, for each type of dismissal, you have different procedures to follow. For misconduct, the procedure generally is that, number 1, investigation to determine the employee's involvement. This typically would include a show cause letter, followed by a domestic inquiry, And after doing this, if the employer is satisfied that the employee has committed the misconduct and that decision of the employer is arrived at fairly, that's when you move into the next part, which is, so what is the punishment? Does this act of misconduct justify or warrant the ultimate punishment of dismissal? Yeah. And where does natural justice fit into this? Supra was quite passionate about this phrase. Where does natural justice fit into this? Now, specifically for misconduct, natural justice has a very emphatic role to play. You will find in numerous industrial court awards or judgments of the courts, the term natural justice is used repeatedly. And what does natural justice mean? Yes, I told you generally the overarching definition of natural justice means fairness. But when we talk about misconduct specifically, the terminology is used to refer to the phrase, no man must be condemned unheard. What does that mean? We shouldn't dismiss someone for a misconduct without giving that person an opportunity to explain their version of events, what they say happened. And there needs to be an assessment of that. Can we believe what that person say, or do we believe that that is not probable, that is more likely to be a lie? So generally, natural justice from a misconduct perspective talks about no man must be condemned unheard. So we are talking about, if I drill down, and I've used some Latin phrases there, I don't want to scare you all, but these are, again, if you read awards, you will find nemo judex in causa sua, audi altrum partem. These are the two limbs of natural justice, they call it. And it's very simple. What it means is that the first requirement of nemo judex talks about no man must be a judge in his own case, i.e. we are talking about unbiasedness, objectivity. The person who's deciding whether an employee committed an act of misconduct or not, should be someone who is unbiased and not someone. It's like the saying, you are the judge and the jury. So you are the person who makes the charge, you are the person who prosecutes, and then you are also the person who decides. That is the worst type of biasness. So nemo judex is the concept of complete impartiality or no biasness. The second rule under natural justice is audi altrum partem, or the right to a fair hearing. Meaning to say, for an act of misconduct which leads to a dismissal, I go back to the procedure which I shared earlier, just up there. Typically, what you want to do is the company undertakes an investigation as robust and as thorough as you can to identify the involvement of the employee. With that investigation, if the investigations show that I think the employee looks like they did commit the act of misconduct, that's when you go to the next step. If the investigations show no way, this employee could not have committed the misconduct because, for example, at the time of the theft, let's say, the employee, we know for a fact, was not in the place where the theft occurred. We know that he was in a business meeting somewhere else, so he couldn't have been the person who stole a particular item. So in that kind of investigations, we drop the case, we don't move to the next step. But if the investigation suggests that the employee was involved, then the right process that I would recommend is to go to a show cause letter. So the show cause letter is basically a letter where we inform the employee what are we alleging against the employee, what are we suggesting that the employee did, and we provide the employee with a fair amount of time to respond to our allegations. So once you receive the response, you assess the response, and if you feel that the response is not acceptable, you need more explanation, that's when you move to the next stage, which is a domestic inquiry. So very quickly, what is a domestic inquiry? It is a platform where the company presents its case to a panel of unbiased judges, for want of a better word. So the company presents its case to say that A, B, C, and D happened, and as a result of this happening, we believe it is the employee who did this, and therefore the employee is guilty of the misconduct. At the domestic inquiry, the employee must be given the opportunity to explain the employee must be given the opportunity to bring witnesses, to question the company witnesses. So the procedural fairness needs to be complied with. And after this process has been done, if the judges of the domestic inquiry decides that the employee is guilty, then it is left for the management to decide on what is the appropriate punishment. And again here, the punishment should commensurate the act of misconduct that the employee has been found guilty of. So that is dismissal for misconduct. And I've talked about natural justice. I've talked about the procedural fairness, which literally the investigations, the show cause letter, and the domestic inquiry. And the domestic inquiry, I could speak 2 hours on that. The process of managing domestic inquiry has to be done really well. It's got to be documented. Why do I say that? If the dismissal is challenged, the court would look into these things. And you need to have your documentary evidence to satisfy the judge that the process and the principles of law were complied with in order for you to be able to succeed or have a good chance of succeeding in your case. So that is insofar as dismissal for misconduct. Let me quickly move to the next topic. Next slide, please, Shadi, where we're talking about poor performance. Now, what are the legal and earlier when I was when Supra asked me a question, remember I talked to you all about the changing goalposts or the moving goalposts. For misconduct, the process that I talked about is completely separate. For poor performance, you don't follow that process. It's not about investigation. It's not about show cause. It's a different process. The body of law has developed to show that the legal requirements for you to justify a dismissal for poor performance, there are 3 requirements. Number 1, the employee must be aware or must be notified about the gaps in his or her performance. You must make it clear to the employee for them to understand where is their gap in performance. If the employee doesn't understand their gap in performance, you are most likely going to fail if this goes to court. So if the employee understands the gap in their performance, then the law requires the second requirement, which is you must give that employee sufficient opportunity to improve. The process that is followed, which typically a lot of HR people understand as a PIP, a performance improvement plan. It's a plan to help the employee improve their performance. That is why the second requirement of a sufficient opportunity must be given. When we talk about sufficient opportunity, we're looking at 2 things. The first one is, how much of time are we giving that employee? You can't expect an employee with a gap in performance to change overnight, to improve or close the gap in a short period of time. You need to give them a fair amount of time. Generally speaking, I will say nothing less than 3 months. But time is the first aspect. The second aspect that I urge my clients to comply with is give them assistance, help them. Do a deep dive to identify what is the root cause for the gap. And once you have diagnosed the root cause, then you prescribe the medication. What can I give to the employee to help him improve or close the gap by remedying the root cause? So it could be training, it could be coaching, it could be counseling, it could be buddy system. Whatever is the root cause, you need to think about what is the best solution to resolve that root cause. And that's the second requirement of sufficient opportunity. So it's not just time. I'd like to see time and tools for improvement. Then you have the third requirement. If you have notified the employee and got the employee to understand the gap, if you have given the employee sufficient opportunity to improve, including fair amount of time and tools to improve, but still you can demonstrate that the employee did not improve sufficiently, the law then allows you to dismiss the employee for performance. Right? So you can see the difference in the procedure, the procedural fairness that Supra was talking about For misconduct, it's investigations, show cause, DI, and then punishment. For poor performance, it's different. Inform the employee, get them to understand the gaps, give them sufficient opportunity to improve. After having done this, you must be able to show that the improvement was insufficient. Once you do all of this, then you can dismiss. Now, there's a question that's often asked: do you need to have a domestic inquiry after a poor performance? The short answer to that is no, you don't need to have a domestic inquiry after someone has gone through a PIP. But I'd like to ask another question. Is it wrong to have a DI after a PIP? It's not wrong. I would even argue that not possibly, I think it will help your case if it goes to court, because a lot of times the employee may say, my input was never taken into account during the PIP. I asked for this type of assistance, but my boss didn't give it to me. I said that I'm struggling in this area, but my boss didn't give it to me. And so if the PIP was undertaken with just a tick in the box, and the employee was found to still not improve, if you have sort of a DI to allow the employee to provide the explanation, it will further strengthen your case. Now, is it an absolute necessity? I wouldn't say that, because again, for performance-related dismissal, the requirements or the procedures are different. But is it wrong? No, it possibly will help you in court. The main challenges for poor performance, a lot of the time, where the gaps are qualitative in nature and not quantitative, very often it can be subjective. So the way in which somebody does their work or performs their task can be subjective. One particular boss may not like it and may say this is not how you do it, but it can be subjective, and that's always one big challenge. Often I've seen cases where the employer didn't provide enough time for the employee to improve and then proceeded to dismiss the employee. Or the employer struggles to show that assistance was provided. If the employee had a significant gap, then it becomes necessary for the employer to show that you helped the employee to close the gaps by providing certain tools for improvement. And finally, the other major challenge is after doing the PIP, it becomes difficult to demonstrate that the employee still did not improve. This is always a challenge, like I said, for jobs which are measured by qualitative measures and not quantitative measures. Sales jobs, a lot more easy to show that the gap is still there because you have a number of items to sell or a ringgit Malaysia value to achieve. And so it's easier to measure the gap. But where it's qualitative, it can be a huge challenge. So this, ladies and gentlemen, are the legal requirements and the procedures on managing a poor performance and the main challenges around it. Shadi, could I move on to the next slide, please? Now, the next area that I'm talking about is dismissal on account of retrenchment. So I think why I'm focusing on misconduct, performance, and retrenchments are because these three areas are the main areas where there is a challenge by the employee. What are the legal requirements for retrenchment? Again, procedure is complete. The requirements are different. The procedure is different compared to misconduct and performance. The requirements here are, number one, the employer decided to undertake a reorganization for a valid reason. So there must be some reason why the employer decided, I want to change the way I'm performing our products or the way we're performing our business. So what is the reason for that? It could be outsourcing, it could be automation, it could be that the company has decided to stop one line of products. So there needs to be a valid reason which shows the need to reorganize. The next requirement is that because of the reorganization, the position of the employee concerned, we must be able to show has become redundant or surplus to requirement. So redundancy is easier. For example, if you've decided to outsource security. So all your direct hires of security guards, you will be able to show, since I've outsourced security, I don't need to hire security guards because the job of the security guard has become redundant. But sometimes it may be surplus to requirements. Because of a reorganization, you want more efficiency. Before you needed 5 people, but now you can do the job with 4 people. So one person is deemed surplus to requirement. You must be able to show that. The third legal requirement is that if you're going to select, like I said, the second example, from 5 people doing the job, you're now going to 4 people. So how are you going to select which one of the 5 are you going to release? That selection process, the law mandates, has to be fair. And one of the main methods of selection that the courts are very fond of and the courts willingly accept is the LIFO principle, which is last in, first out. The employee which has more years of service is secure compared to the employee with less. And the last requirement is very important in retrenchments. There must be zero element of what is known as mala fide or bad faith. So you cannot be focusing or being vindictive towards one particular employee. There must be a good reason for the reorganization, and the selection process must be done objectively, fairly, without any bad faith or without wanting to target any particular employee. Yeah. The main challenges for retrenchments that I put down there is, a lot of times we look at cases, there is no evidence which suggests there is a need for a reorganization. A lot of times the employers end up losing because it is shown that the position of the person who was released was not redundant, because after they let the person go, they're going to hire someone to replace that person, which in itself shows it's not redundant. The other main challenge is LIFO. Very often the employer wants to release someone who they view is not as good a performer as someone else, and it often happens that the person who they want to release has got more years of service. So to comply with LIFO is a major challenge. And one very important aspect for retrenchment is the insufficient notice. Not enough time is given for the employee to digest that they're going to be released, and therefore employees don't accept that very well. So it becomes a challenge for the employer to give as much notice as possible. So this is insofar as the procedure and the legal requirements for retrenchment. Can I move to the next slide, please, Ashadi? The common errors that I will talk about, and let me run through this fairly quickly. I know that we've got some questions which we'd like to address. If you want to come to a stage where employees who are released don't file a complaint, what are the common errors that you want to avoid? Number 1 on my list is prejudgment. I give you an example. When it comes to misconduct, the employer, before they even begin the investigations, in their mind, he did it, I know he did it. So there's already a judgment that the person is guilty. And when you start with that kind of thinking, I will tell you that the likelihood of you not being fair in your procedure is very high. Number 2, lack of or ineffective communications. I am a strong believer that if you communicate properly, if you show empathy, if you treat someone with respect and dignity, I believe that employees can accept the decision of the employer to release them. It is the manner in which you communicate, and I put that down as a 4th point, giving them enough time, especially like in a retrenchment scenario, giving them time that this exercise is coming, why we have to do this. Unfortunately, you have been selected. How did I do my selection process? So if you do proper communication, you don't prejudge the situation, there is a higher chance of you getting buy-in from the employee. And that gives you a better chance of the employee walking away without wanting to challenge you, and so there are no complaints. But if I go to the second definition of success, which I referred to earlier, if you end up in court, what are the common errors that I've seen from my experience that employers have made? The first one is, of course, the non-compliance with the law or failure to comply with the procedural requirements. No DI is done for a serious misconduct. There's no performance improvement plan, or If you talk about a retrenchment, you don't follow LIFO, you don't have a proper reason for a reorganization. People who are not redundant are released. So non-compliance with the law procedural requirements is one of the main areas why employers end up losing in court. Number two, you don't have the evidence. You didn't document the process properly. You didn't document the procedure properly. Or even if you did, when you go to court, the right witnesses have to be in court, because ultimately the judge is going to look at all of this and make pass judgment. They're going to judge who to believe. And if you don't have evidence, you don't have the right witnesses, that's one major area of concern for me. And that's one of the main errors that you have that employers make. The last one I will have to say is ineffective representation. When you are in court, especially if you're an employer, you need to understand that you must have a solid strategy. You need to have excellent documents which set out your strategy. And most importantly, I spend a lot of time preparing my witnesses, because the witnesses have to perform in court. So these three are the main common areas that employers face when you end up being in court. And I think that is the last part of my presentation for today. I hope you found that useful. And maybe let's bring Supra back in to take some questions. I see there are a few questions that have been posed in the comment section. Back to you, Supra. Supra, you're mute, Supra.
You continue to surprise me, Daman.
I hope pleasantly.
In a positive way. Okay, first question on the list is, it's like a menu here, right? Explain on the frustration of contract. I think that what they wanted to know is, what does a frustration of contract means, and how does it come about? Number one. Number two is I think it's referring to medical board out. How do you actually handle the medical board out?
Okay, so frustration of contract basically refers to a situation where something has happened which is beyond the control of both the employer and the employee. And this thing which has happened makes it impossible for the contract, the employment contract, to be continued. So examples of this would be if war breaks out, natural disasters. So these things are beyond the control of employer-employee. And because of these things, the contract cannot be performed anymore. And therefore, the contract can be terminated on grounds of frustration of contract. Now, for medical boarding out, it's there are two ways, in my opinion. The first is the easier way, where you have a certification from a registered medical practitioner, which in very clear terms states, as a result of this employee having this medical condition, they cannot perform their jobs anymore. Now, if you have that kind of documentation from a registered medical practitioner, yes, the employer can terminate the contract. The second time you can medically board out someone is where an employer has a prolonged illness leave policy. So they put the employee through the prolonged illness leave. Typically, it could be 6 months full pay, 6 months half pay, 6 months no pay. And at the end of that 18 months, unfortunately, the employee is still not fit to come back to work. You can then terminate the contract on grounds of medical board out. So that's what I say for that question.
Thanks, Raman. Okay, but on the timing factor, it doesn't need to be 6 months, 6 months, 6 months, right? It depends on the company's policy, where it could be 3, 3, 3 or something like that.
Yes, absolutely.
Okay, just to clarify with you on that. Okay, next question. Termination for non-performance requires the termination notice, right? Because under misconduct, you don't have to serve the notice. So in non-performance, do you need to pay the notice?
Yes, you would have to. And I'll tell you the reason why. Two reasons. The first, the simpler reason of the two is that in the Employment Act, they will tell you that for misconduct, you can summarily dismiss. So summary dismissal is dismissal without notice. And that is the only instance of a dismissal without notice. The second reason why I tell you for performance you should give notice is performance doesn't have that element of intention. The employee, unlike a misconduct, did not intend to do something wrong. But for whatever reason, they're not performing well. And so at the end of that contract, the right thing to do is you have to give notice of termination. Of course, the relationship is a little bit sour, so you may not find that to be useful. In that instance, what I would recommend is payment of salary in lieu of notice. But yes, you have to give notice.
So my question is, say in a situation where, okay, it's a probationer, right? Where the probation expires in 3 months, expires, say, end of May, okay? And I've got 2 weeks notice. Do I serve the 2 weeks notice for the non-performance, right? The notice to terminate after end of May, or I could serve by middle of May?
Okay. You can do it in either way. The caveat that I would say is that when you do serve that notice, whether it is before say in the middle of May or at the end of May, in either case, you must be able to show that the three things which I talked about, the employee was aware of the gap, sufficient opportunity given, and despite that, there is still insufficient improvement. So if you have that in the middle of May, you can serve the notice then, and then the the termination takes effect end of May.
Okay, next one. Can I terminate a sales staff who didn't bring in any single sales for the last 3 months?
Okay, so I would again say that would fall under the category of performance. So if the employee is not brought any sales at all for 3 months, I think that certainly qualifies for the employee to be placed on a PIP. But I wouldn't terminate straight away. In fact, I would suggest that you wouldn't even want to wait for 3 months. Let's say you see first month no sale, a good line manager would start to intervene and find out why, and start to identify, hey, listen, I think there are gaps in your performance. This is what you're doing wrong. I think you got to do this. But you need to initiate some level of performance improvement plan before you terminate. So what I wouldn't encourage is 3 months no sale, 4th month straight away dismiss. Yeah, I would suggest you go through that performance management process.
Okay. The next question, how to conduct a PIP?
Okay.
I think this would be something we will cover in our next webinar series in detail, but maybe you could give a brief outline of it.
Okay. So again, if you look at the aspiration or objective of a PIP, it is to help the employee improve. And if it's to help the employee improve, what we should be doing mainly 3 things, right? The first one is what is causing the poor performance. You want the PIP to nail that. So if I use sales, for example, it could be because the employee is not seeing enough people, and that's why sales are not there. Or it could be because employee may be seeing enough people, but his product knowledge is not there. That's why he's not converting. So you need to drill down to fix, to sort of diagnose what is the problem. So cover that. The second thing the PIP should do is what is the medicine, like I said just now, that I can give this person to improve in that area. So if you're not seeing enough people, I would look at, okay, your prospecting skills is poor. All right, you need to get more database. So this is what you got to do. So the third part there is I will give the tools on how to do prospecting better. Right. So a good PIP should do these 3 things: identify the root cause, identify why is it that this person, what is it that this person can use to improve, and then the third one is keep monitoring to see if the person is on track. If they're off track, bring them back track. So in short, I would say that that's a good PIP.
And also, like what you always say, document, right? because you can't remember this in court later.
Absolutely.
Okay. Okay, next question. Are all types of machine operators, supervisors, truck drivers, were considered under the EA, Employment Act?
Okay, I would say that generally speaking, the truck drivers, yes, because there's a category specifically for them. Anyone who operates or maintains a mechanically propelled vehicle comes under the scope of the act. And please remember that may be the case even if the employer is earning more than 2,000, right? As for machine operators, I would say you need to understand whether the operation of that machine amounts to manual labor or not, because it could be the case like today I might be operating a drone, I might be operating a highly sophisticated machine which requires me to be an engineer. Now in that instance, although I'm operating a machine, it's not predominantly manual in labor, right? But if you're in the manufacturing line and you're in one of the lines, that kind of machines, yes, I would say predominantly engage in manual labor. As for supervisors, very important to understand, the Employment Act talks about supervisors who all they do during their time of work, during the hours of work, is supervising manual laborers only. So if the supervisor is doing 20% supervising manual laborers and the rest is doing other things, he is not someone who comes within the scope. The Employment Act specifically mentions supervisors of manual laborers in and throughout employment. So that means the whole 8 hours is supervising manual laborers. Classic example is a Mando.
Okay, next question. After PIP, employees still within the time frame still fail to perform, should the company still conduct a DI? Can you just give the notice to terminate?
Okay, I would say that yes, you can give the notice to terminate. But as I mentioned earlier, if you have a DI, it gives, to me, if it goes to court, I can see that as being another bullet in favor of the employer, because it shows to the court the employer wanted to ensure that the PIP was super robust, and that's why another session was held to hear the employees' views on it. But I wouldn't say it is mandatory after a well done PIP. If a PIP is done properly, where you've heard the employee, you've taken into account the feedback of the employee and considered that in the management of the PIP, I don't see it as being necessary. It's not. You can issue a notice of termination after the PIP. Having a DI, I would certainly say is an advantage if it ends up in court.
Okay, next question. I've got an employee who's got a 3-month probation, and she has completed the 3 months probation, and I'm not happy with the performance. Can I terminate, or should I extend the probation?
Okay, so again, to me, see, the probation period is sort of an implied PIP. If during the probation period, and maybe let me just step back a little bit. Even a probationer who has been released upon completion of the probation period can file a complaint under Section 20. Okay, the difference there is their back wages is capped to, or their maximum compensation is 12 months. So, to me, if you can show during that 3 months of probation that you can show that the employee had gaps, they knew of the gaps, you had given opportunity to improve, then you can proceed to issue the termination. But if you don't have that, and the employee is not even aware that they're not performing, I would strongly recommend extension of probation, and a robust performance management is undertaken during that extension period.
Thank you, sir. So next question. I've got an employee who has been confirmed. She said that she could perform 3 particular job roles. Job roles not mentioned here. So when we hired her, right, she's supposed to perform 3 roles, and she was confirmed in the employment. But lately, through our audit, our auditors highlighted there are some errors in the job. I think it must be related to finance or in accounting, right? And after confronting the employee, we realized that the employee can't actually do the accounts and finance job well. Therefore, she now decided that she doesn't want to perform the role. What do I do? Can I now put her on non-performance and terminate her, or should I accept the fact that she can't perform the role and hire somebody else? But then the question is, what do I do with her position that she's not performing this and the company is going to incur more costs?
Okay. One
That's
concern that I have.
a very long question.
Understand. So one concern I have in that question is the employee was confirmed. So we need to understand that suggests the employee was performing their task properly, right? But maybe at that point it wasn't the major accounting function she didn't have to undertake, so the company didn't identify the gap. But subsequently, if there is a gap, and if to me, if that role where there is a gap is the predominant role of the employee, so let's say they got 3 roles, and that particular single role is 75% or more of the role, and the other 2 are ancillary roles, then I would suggest in that case you probably want to go down a route of PIP and release the employee. But if the role is not the predominant role and it's equal weight with the other 2 roles, and the employee can perform the functions of the other 2 roles satisfactorily, what I would recommend is enter into discussions with the employee to say, hey, you are not meeting the expectations of the 3 roles. This one particularly, there are gaps. You have now yourself mentioned you don't want to do that role. Fine, we are okay with that, but there has to be a quid pro quo. So if you're going to reduce the roles, it must come with a commensurate reduction in salary. So there is a renegotiation of the terms and conditions, and I think that would be the better way of doing it if it's 3 equal roles.
Okay. Thank you so much. I think there are more questions, and I don't think we can cover. We also got to respect our Muslim friends who's going back for their fasting, break fasting. So, on certain other topics like PIP, involuntary resignation, domestic inquiry, please stay tuned with EPLI, right? And we will be running all these programs as on a monthly basis. And I'd like to thank Mr. Daman for always being here and supporting us. And thank you, all of you. And I think it's a really good turnout. We've got 600 over people who actually registered. Thank you so much. I hope you learn a lot from this and continue to follow EPLI. Thank you so much, Sukhdev and the team.
Thank you, Supra. Thank you, everyone. Hope you found that useful. Have a good day and a great weekend, everyone.
Bye.